based on our conversation last week, we are being filmed today, and it was a consensus of the group that we would be filmed, which is great, and thank you for being here. And I kind of open it, but I'll let my co-chair, of course, we work on this in tandem, and then I hope we'll go to introductions shortly too, Rick.
No, I have nothing else to add. I think we're ready to move along once we introduce, because we do have some new people, and it's great to see the new faces that are here, and appreciate the ones that were here before coming back. So if we can just start around the room, maybe Meredith, go this way.
Meredith Machen, Legal Voters of New Mexico.
Katie Feldman, Common Cause, New Mexico.
Rob Black, the Association of Commerce and Industry.
Damon Eli, State Representative for District 23.
Pamela Blackwell with New Mexico First, listening a lot today.
I'm John Blair. I'm the Deputy Secretary of State.
Maggie Toulouse Oliver, Secretary of State.
Matthew Baca, and I'll be the analyst for the Rules Committee.
Norm Gagney, with the Judicial Standards Commission, but not here for them, here as a citizen.
Kathleen Sabo, New Mexico Ethics Watch.
Mariana Padilla with Governor-elect's Office. Stephanie Keene with the Governor-elect's Office.
Diane Goodman, Citizen.
Tony Ortiz.
Everybody, okay, good, and welcome. We were talking about jurisdiction since Madam Secretary was bringing it up about, I guess to me it sounded more like concurrent because we haven't made a decision on the jurisdiction issue. So what is exclusive still on the table for you all, or are we moving from that now to go to maybe concurrent or primary?
Well, I thought that maybe this is a suggestion. There may be folks who like exclusive, there may be some who like concurrent, and maybe what we do is what Douglas and Tony have done is simply put in there an either-or approach, because otherwise we could get bogged down just upon the different philosophies that people have towards how jurisdiction should be handled. And because I think what we're trying to do out of this group is simply show, to put out there some parameters, knowing that we're not going to have a consensus on every issue.
Okay, because if you notice what was put in here on the copy, and thanks to both gentlemen here to my left, on page 10, 11, and 12, they did list, of course, the issue on exclusive, and then you have concurrent on page 11, which is on my kind of faint, but it's there, and then on page 12, primary.
And we did that, Madam Chair, and I apologize for being late. I had another meeting I couldn't miss this morning. In response to, I know Senator Feldman and some others wanted to know what they look like. And so that's what it would look like. And then up at where it says alternative to 1, 2, 3.
Right.
That's the category when you look at. We don't necessarily use the language, but that's what it would mean effectively, and how that would play out.
But traditionally, when you do legislation, you don't put options in there. Sorry, but I don't mean to be dismissive. I'm just trying to move us along so that we can choose one, and then if it gets amended, it gets amended during session. Just because normally I have not seen where we have several options in there to choose from. You kind of choose a direction. If it gets amended or changed in some venue, that's where I would look at introducing.
But I think, Madam Chair, this is not a bill writing group, as I understand it. This is basically what is being discussed by this group to bring to the legislature for purposes of then the legislature seeing that there may be, and then it's up to the individual legislator to write their own bill. And this group here would be able to give some framework to that legislator as to these issues were discussed. We got it down to we got it down to exclusive, we got it down to a concurrent. But then it's really, I just did not envision this to be a bill writing group, because needless to say, we're not going to finish writing this bill in the next hour and a half or 2 hours. And so it would seem to me that the legislator who's going to write the bill or sponsor it then would have the benefit of at least some framework that has been discussed here. That's how I saw it.
Yes, and how I was seeing it is that we could use this as the baseline to throw in as a bill with some changes of, stylistic, depending on whoever we work with in council service, to kind of, make a few stylistic changes, and then from here we could use this as part of our discussion to start during session also, and then of course the game's on, and here we go for all the other amendments that may come, or committee substitutes, which most likely will happen, because I think I've already heard of maybe 5 other legislators who will be introducing a measure too, so there's still more to come. And this could be part of at least a submission saying this is part of what our work group has been working on since the summer. And this is kind of where we are at this point, and here it is in the fray. And that's kind of what I was hoping that we could do as we move forward with this too.
So your approach then would require a vote of this
No, we're not.
as to which was preferred, concurrent, exclusive, or primary?
Not necessarily a vote. We were trying to work originally from consensus. So it's kind of like looking as to if there's really heartburn against removing, but we have to make a choice. And you can't just, this is my perspective, maybe the way I operate too, and there's always differences of how we operate, is that we make a choice, exclusive, concurrent, or primary, throw it in the fray, and then it's part of that discussion that some of us may want to come up there during session and argue on behalf of why the group felt in consensus is saying that, most of us could live with it, not coming to a vote, and kind of going forward from there. Because as, some of you who have served in the legislature, of course, we all kind of see and know how some of our colleagues are, and it's going to get amended, and we'll have some committee substitutes that show up in either chamber. So, and then we still have to have the governor's perspective on this too, as to how this will affect her administration and what she needs to see move forward. So, in answer, Dee, it's kind of like, if there's no heartburn, if you want to leave exclusive, then that be it. But I think the person sitting here just kind of, I didn't hear that from her. She's a big part of this whole conversation that we were having on ethics, especially as it relates to elected officials. So I just want to throw that out. If you deem that you all want to throw this in and go with how you had envisioned this representative, I'm fine for that too. But I know I will borrow a lot of this from a bill that I will drop also, just so you know, because we've done some good work. And I'm sure Representative Eli will be more than, we'll talk. But however you're going to introduce something, that's your purview in the House also.
Yeah, and Chair, I don't mind. I think it makes sense to kind of get a temperature of the group without taking a vote, just to see if we have a consensus. I was actually in line with the idea of exclusivity until I heard this and started talking to people and talking to Norm, that I thought, yeah, concurrent. What I don't like about exclusive suddenly is the same thing we're facing in other areas, which is we're building silos. And that's a bad idea. And I really worry that what's going to happen unintentionally is that the commission will be kind of jealous of its powers, the Secretary of State theirs, and I'd much rather build into legislation something that allows them to partner and gives them the flexibility to do things. So, I kind of come at this now in a totally different way, where I'm much more open to a concurrent approach. I did agree with Jim at the beginning that I thought exclusivity made sense, but I don't anymore. And I think listening to the Secretary of State, it's like what we're doing in criminal work is the same thing. Everybody's got these silos, they don't talk to one another. We are spending tons of time trying to figure out how to build a system to bust down those silos, and I think everybody at the table on this would make some sense.
Madam Chair, I think having concurrent jurisdiction does not necessarily do damage to Jim's concept of a one-stop shop, because if it were done right, a complainant could come to the commission, the Ethics Commission, and make a complaint, and if it were not something that the Ethics Commission was really equipped to handle because of personnel limitations or expertise limitations or whatever it is, they could either refer it out or work in conjunction with another agency so that the complainant would come to that one-stop shop and get get relief with a meritorious complaint through the Ethics Commission, but not necessarily handled exclusively by the Ethics Commission. And for the reasons I mentioned a little bit ago, I think if you adopt an exclusive jurisdiction, you run a real risk of loading the commission down with a job that it just, under any reasonable staffing situation, it probably can't handle, or may not be able to handle at any rate. And with that, I've stayed longer than I'm supposed to, so I'm going to excuse myself. But thank you very much for letting me participate.
Thank you, Norm, for being here.
Madam Chair, if I may, on this question of concurrence versus primary, the key paragraph on both of those, or subparagraph, is B. So this would be on, actually they both end up being on page 11. And primary is really just another form of concurrent in some ways. When I was crafting that language, I was thinking what Representative Dines said all along about a one-stop shop. And that was what we discussed, some of us around the table last meeting, that everything would go through the Ethics Commission, but the Ethics Commission can then farm it out. Versus the concurrent, and it's at paragraph B, it's at the very top of page 11, is truly, it's almost more silos, and it would allow people to drop complaints in 2 different places if necessary, which I don't, on one hand, I know I can see Representative Wheeler shaking his head. Many people have said, we don't like that idea, there's forum shopping. Others I know have said that's a check to, if you get a commission that's not doing its work properly, you have another place to go. So there's policy trade-offs with all of them. And I'm not, I laid all 3 of these out here as a shopping list. I don't have any dog in this fight one way or the other, but I want to point people out, particularly to that paragraph B in concurrent and primary, because that's really the key mechanism of this discussion, just to give language to people to react to. And again, I don't have a dog in this fight for any of the options. So I just wanted to say that, Madam Chair, thank you.
Yes, ma'am.
Douglas, I'm sorry you were here to hear that great discussion, but what surprised me was hearing how much the Secretary's office wanted to retain that they're currently doing. Everything from audits in the Campaign Reporting Act to education under multiple acts. They'd like the Ethics Commission, this is just their perspective, they'd like the Ethics Commission to have the investigatory sort of procedures because they don't have any investigators. And so I was at exclusive at one point too, and now I'm thinking concurrent. But when I look at concurrent in here, I'm not sure it's exactly what the Secretary described. So it seems to me there need to be a little massaging of that. But I'm sorry you missed that discussion because it was a big surprise to me how much that office wanted to keep, but it makes sense because they have some really effective structures and the knowledge base and the expertise. So that's all I wanted to say about it.
Good, Madam Chair. Go ahead.
I'm wondering, Madam Chair, Mr. Chair, if perhaps we could strike all 3 of those options, exclusive, concurrent, and primary, and use the wording that's in alternative 3 and just say the Commission shall have jurisdiction to enforce the applicable civil compliance provisions, and leave it simply that way because essentially it's enforcing, whereas we've heard from Secretary of State that they don't have the ability to enforce, and the word applicable is so powerful, the applicable. So in other words, it wouldn't be, something that came to the commission that would be applicable. It wouldn't be like, uploading the wrong spreadsheet to their campaign finance report. And that way we don't get into all of this, frankly, the wording that's in B and C and D, so helpful. And, I honestly think that it would be under the purview of the commission to say, hey, this goes right back to the Secretary of State. This is frivolous, or, this is minor. This is not something, but where we have a true conflict of interest issue, that is something we want to enforce. So you're giving them the discretion to deal with, enforcement and referral.
Oh, Ron, I'm sorry.
I was just wanting to make sure I understood what you were saying, if I could, Chair. Did you, on top of page 12, did you say the commission shall have
Jurisdiction to
not
enforce.
have primary?
Yeah, jurisdiction to enforce the applicable civil compliance provisions. All I'm saying is strike it, and then not have the alternative 1, 2, and 3, of it. And because I can see the dogfight going on forever during the session, on these 3 words. And I honestly think that, that can be ironed out by procedural, and rulemaking and so on, and by the commission.
So to that, I guess my concern would be where you have, if you don't have some guidance as to where an investigation or enforcement should begin, or who has primary jurisdiction over it, you may have multiple forums that you're dealing with as someone who's been, as a complaint against them. So if somebody files across a spectrum, I may have to answer to the Secretary of State and the Ethics Commission and other entities. And that becomes very burdensome for individuals. So I would encourage, I think the recommendation, but I would leave the word primary, because I think you want a place for people to go to start, and it will, I think if I'm understanding how we're trying to use the word primary, it would permit the Ethics Commission to say to the Secretary's office, we need you to investigate around the campaign filings and the timeliness, and do we think then there could be an investigation whether it's malicious because they have the ability to request documents, but it would allow them to kind of be that primary point, and I would favor that, I think.
And if I may, Madam Chair, Representative Dines, in many ways, that's how Judicial Standards Commission works. That's where complaints against a judge go, but that doesn't preclude the commission from relying on, reaching out to other state agencies. And so I think primaries, we're all actually talking really about, in many ways, primary jurisdiction and the primary language or concept to avoid the silos, to avoid forum shopping. You have one-stop shopping for the citizens of the state, but they could either turn something over completely or agree with the Secretary of State's office due to staffing and whatnot. It's like, okay, we won't handle any of these issues, we'll just kick them all over. Because there's nothing saying why the commission can kick it over. They can kick anything over. It allows them to defer. But there might be things that they can hold themselves. And then as the commission's expertise gets built up over the years, they might want to increase that pool. And maybe the secretary, won't, or maybe they'll end up getting into a jurisdictional squabble, and that happens. We see it with our magistrate and municipal courts in the state. That can happen, but it would allow that kind of balance to take place. But I agree with Rob that we need something.
Okay.
We can't just say jurisdiction, because then you end up with it being unclear in the law where to go.
Well, Madam Chair, I think that the way Douglas described it is what I was thinking that would be a good way to have to me, the word is not the important part. It's basically what is it going to do and what jurisdiction will I have. So we get away from the semantics, and then we take a look at the fact that right now we're diffused because we've got, you can go to the Secretary of State's office, you can go to the Attorney General's office. Cliff Reese gave us that information about different agencies or departments that do their own thing here and there. And I think if we're going to stick with that system, then why even have the commission? because all you've done is put another layer of government on top of the people to pay taxes on in order to have people working there. So basically then, it would seem to me that it ought to be to where the citizens are able to go ahead and file with the Ethics Commission. But I remember Representative Eli's comment about the fact that they could go ahead and maybe file for Secretary of State, but Secretary of State would immediately send it over to the Ethics Commission as the clearinghouse on where this goes. It shouldn't be left up to the individual department, to me, to make that decision. Because if that's the case, then why have the Ethics Commission? And if they're only going to deal with, let's say, enforcement, then we should just go ahead and have these agencies or departments, you know, put something together for their enforcement. So it seems to me that if our citizens want to file an ethics complaint, they know they can go to the Ethics Commission, they know that the Ethics Commission will be the clearinghouse to determine then the path that this particular complaint will go. And at that stage, if it needs to go to the Secretary of State's office or wherever, then it could. But I think that if we don't do that, then what have we really created other than an extra layer of government?
So my hearing primary sounds feasible. I'm sorry, yes.
I mean, I do think words matter. And the word concurrent, although really in practicality, I agree with you, Doug, it's pretty much the same as primary. The word concurrent makes it seem like you can go to both agencies at one time. And you know, both of them will be doing their own thing. And that's the kind of confusion I think that we wanted to avoid. The word primary doesn't preclude cooperation. I think that's what she was asking for. She was asking for cooperation between the Ethics Commission and the attorney and the Secretary of State's office. It was clear to me that yes, she did want to retain jurisdiction over education, but she wanted help. She wanted help, and she especially wanted help with a more robust kind of investigation. And, you know, there were certain things that she could do, fining, but the other thing she already has to hand over to the Attorney General's office, I guess misdemeanors. She doesn't do it much because, I don't know why, but it doesn't seem to happen that much. But she was looking, I think, for a partner. It sounded like to me. Not a competitor in any way, but a partner. And I think the word primary, and incidentally, all three of these options here use the word primary, concurrent, or exclusive to enforce. That's the common denominator, to enforce. Applicable is important too.
Yes,
that word
yes.
applicable is important too, because not all, like as we saw, she didn't feel that, you know, the procurement code and the Whistleblower Protection Act and all those, maybe even the Gift Act was very applicable to her office. Just the campaign finance, the Voter Act, the, I don't even know whether the Local Elections Act would be, or the lobbyist one. Yeah, the lobbyist one, definitely. Mm-hmm. But anyway, so if I had to choose here, I would use the word primary. And, you know, and I think the message it sends to the public is that this is where you go with your complaints, and they will also be filed by that commission in a clearinghouse fashion to other applicable agencies.
Okay. Any other comments? Nobody? No? Rob? Yes, ma'am.
On that, I think on the point that you keep on making, the one-stop shop where people will be able to, file a complaint. The reason I like that idea is for tracking purposes. I can see if it's concurrent, that it could get swallowed up and forgotten in an agency and never, it could be, I'm not saying any personalities that we currently have, but, it could be forgotten, not investigated. Even that whole voluntary compliance, people go dark, nothing happens. If it goes to the Ethics Commission, and let's just say, that it's tracked, and, it's gotten a date stamp, and hey, then something comes in, you can refer back, oh my gosh, this happened in the last election. This happened, in a school board election. And, there's a tracking mechanism so that it's not something, that is just lost in an individual department's agency's database.
Thank you, yes, sir.
I think that's a great point, and I had some concerns about the idea of bringing in a procurement code, whistleblower, State Personnel Act within this jurisdiction, because I didn't feel like the commission's role was really employment law or employment relations. However, I do think it's important to have a clearinghouse and a tracking for accountability purposes, because I think it can get sent into a black hole. So I think one way to think about it perhaps is to say, and maybe we should be explicit about it, but that if they're the primary jurisdiction to enforce, they do have the ability to delegate enforcement activities to other departments, but will maintain the tracking and resolution and communications back to the complainants. So that there's an accountability to it, but it allows HR, or if it's an employment function, that they should be the ones really administering it versus a commission whose focus is in employment law. So that would be my concern on that, is that but I think if you allow for the ability to delegate to other departments, but track, I think you could maybe solve for that.
And then, Madam Chair, I guess the next question we would have is, and I'm understanding the reasoning of all this, but the next question we have then is, what is the commission then retain? What is its purpose? If it's clearly and solely a clearinghouse. In other words, where would you put in there, or how would, because my concern would be that there might be some kind of a turf war then going on. One of these other agencies that, so wait a minute, this is ours, this is our baby, and you don't have any right to do this. And so, what is then the commission going to do? What would be their purpose? Other than a clearinghouse, which is the way Meredith explained it was excellent. But what else would they have retained to do?
I would think they would still have it depends on what they would delegate, I assume. Is if they decided they were going to continue the enforcement of the GIFT Act or the financial disclosure audits and those sorts of things, they would retain that jurisdiction, but they were primary for it. But where they don't have the expertise, that would be the ability to delegate to others, but then to hold that group accountable to bringing the complaint to a resolution of some sort.
And filing a resolution.
And reporting out that whether or not those have been done.
And Madam Chair, then Rob, would the commission have the sole authority to delegate? Because if you don't give them the sole authority, then the question becomes, is going to be one of the other groups saying, no, that's my purview. If the complaint comes into one place and they would have the sole authority to be the delegator, if you will, then I think that makes a lot of sense. Short of that, I think we're back to the fact that we, as Representative Eli said about silos
and having that turf war.
Madam Chair,
Agreed.
Representative Dines, on that point, you're actually, our minds are kind of working in sync, I think, right now. Because
Well, that's a compliment, you know, from,
I don't know.
from you, I
I've
appreciate
worked so much
that.
for verdict review, so I think that's why we're in the same place. And thinking about all these comments, I thought of some additional language that we'd have to fold into the primary option, alternative 3. And one would be probably requiring an agency to forward a complaint to the Ethics Commission, first of all. And now, there's a little bit of paper chasing going, so it goes to the Secretary of State, gets kicked to the Ethics Commission, and then they kick it back to the Secretary of State. But I think that requirement helps prevent some of that forum shopping and makes pretty clear the legislative intent when jurisdiction gets challenged, which it will be at some point. There's going to be turf wars and someone will take it to court, that the legislature intended the Ethics Commission to be, well, actually to be the primary jurisdiction. So I think if you require complaints of many of the underlying acts to go to the commission, then that gives the commission the authority to delegate it out, to kick it out. We also might want to write language allowing the commission to split a complaint, because you'll probably get complaints on multiple issues, and they can retain enforcement of some aspects and not of others. And we also might want to write in language allowing, basically, it's like a dual jurisdiction investigation, essentially, allowing them to work in conjunction with other agencies, and taking it from what I gather the Secretary discussed this morning. So they could truly work in partnership with other agencies. And some of this will have to just to be, it'll probably depend on the nature of who's chairing the commission and who's the Secretary of State. And I'm sure over the years, these things will be meshed out. But I think those are some language tweaks that will make it clearer, what the intent is to be. That really the Ethics Commission sits on top of all of these acts. And then they...
Sort of the court of first recourse.
Essentially, yeah.
Commission, I guess, of first.
Commission of first recourse.
The first step, I had written the same thing on my thing, and it could apply to both concurrent and primary.
Mm-hmm.
Yes, ma'am?
Excuse me, pardon me. I'm getting a little hung up on only having enforce in there
Yeah.
rather than including investigate. I mean, are you thinking that enforcement sort of encompasses the other functions? Does my question make sense to you?
I believe it does, and Tony can speak to this, but the commission already has the authority to investigate anything.
Okay, in the Constitution.
Well, in the Constitution and in a different section.
Okay.
So they have the authority already they can investigate
Okay.
whatever they want.
You don't need to repeat what was in the constitutional amendment in this? I would think you would.
Yeah, it doesn't hurt to repeat it, though, does it?
Doesn't hurt.
Yeah,
My view is actually it could hurt, because if it gets amended later to be in contrast with the Constitution, it's invalid. I prefer not to.
But if you're paying attention to when you're also having legislation written,
Right.
you're gonna make sure that's the primary that comes out of the Constitution, you're just changing maybe some of the other facets. And the public also looks at this, they're not gonna go back to the Constitution constantly. I think we could just be reiterating what's in there, but I actually would like to see where we talk about issue advisory. I mean, there's still, because the commission shall have primary jurisdiction to enforce, investigate, and advise. I mean, there's some things that we could also look at in there too for what the commission's to do, what their primary role is. If it's, I prefer to have something written like that. It just
Kathy was saying.
kind of
also.
what you're saying, it just reinforces.
Yes, and
Because then we have learned people who work in council service that will always remind us you can't take that word out because that's in the Constitution. That's why we have these folks who we formerly, but still retain that training and such, where they always tell us, and they've told me many times, sorry, but we can't touch that because that's in the Constitution. Oh, okay, thank you. We're reminded.
And Madam Chair, to answer that question, and Kathleen, on page 8, And it's, the read is a bit confusing because the heading for that section is at the bottom of 7, Commission's
Okay.
duties and powers.
Uh-huh.
It'll, but it's on top of A1, meet as often as necessary. A2, administer the applicable civil compliance sections set forth in section 8. So that's what we're talking, about how section 8 works. And then receive and investigate verified complaints that allege an ethics violation. So section 8 is folded, and then in 5, section 8 comes through again. Promulgate rules, implement and administer the law set forth in section 8. So section 8 is folded into the commission powers here. And so the section 8 is kind of talking about slightly different issues. It's about the enforcement powers that it has. But those are folded into the principal duties, and this gets to your point, Senator, there. And I think that's enough of a tie to it.
That's how I read it.
Just differences of copies are written, but what do y'all want? Well, this is going to be something that'll be dropped in, and then of course it'll be amended. There'll be, like I said, I know 5 other bills that'll be dropped. Maybe
Madam
more.
Chair, there's also going to be 100 pages added to it. The underlying acts are all amended.
Oh, totally. So it'll be about 100.
Yeah, so people shouldn't freak out when an 18-page bill becomes a 118-page bill.
At least.
Because every underlying act will have to be touched.
Right.
So,
Well, it seems to me, Madam Chair, if we would go ahead and put as a preface at the beginning and the end of this document, that this was a living type document, that please note that not everyone may have agreed to all of the issues, but these are the ones discussed that we went forward on. And with that being the situation, it seems to me that the language that Douglas mentioned probably seems to cover much of what we've discussed on this issue. And so I'm not stuck on the word exclusive. I'm more stuck on having language that defines exactly what it does versus a title. And so I certainly think that maybe what Douglas mentioned as some language might be satisfactory, that it encompasses maybe the discussion that we've had.
So Madam Chair, what I'm hearing here is kind of the disparity between whether this is going to be a report coming out from this group or whether it's going to be a discussion draft, and perhaps both. And I don't know the answer.
Yeah,
I don't know
I
what
mean,
you want to do.
We had presented in front of Courts and Corrections Committee, and it was presented as a discussion. We discussed what we came up with. We gave them the draft that we had at that point in time for them to peruse through. There were some questions asked by some of our colleagues at that point in time, and some good questions, and just, I think, a showcase of what's to come. But I think, and that's where I caution just to say, I think that with our working group, at least for us to have something to throw in the hopper would be a good ideal, so there's another context that those of us who will be there on one side of the table, those of you who may be coming back to advocate also from the other side also, it's a living document, it's something that we have to go through, but the reality is that this will be folded in with other suggestions that other members will have. So we may have some of it in there, we may have, half of it, a quarter of it, maybe 3/4 of what we have. I don't know, I can't predict that just yet. But what I'm hoping is that we have something, even if it's just a light shell. We may not get on everything, because subpoena power is still something that we haven't discussed, but that'll take another 10 hours to go through on discussion, but we can leave that, something in a space in there, just with the idea that this is a discussion draft. But I would like to have something that our working group can have that's introduced. Even if it's just a shell, but at least to me it's a showing of a product, because the report nobody reads. We're too busy everything else, like, oh yeah, another report. I'd like to have something that we can refer to and say this was part of our efforts for how many meetings we've been together since the summer. Representative, and some of you have been with us, of course, since the beginning. At that, it's just, to me, it's just to honor what we've been doing. So
Well,
if that answers your question a little bit.
And my concern is the fact that I would be very hesitant to have this document stand for me. And I think if it is put in as a draft bill without some kind of language that indicates that maybe not all members agree with this, that would be fine. But there's things in there in the draft that I've already registered concern about, and others have. Let's get away from jurisdiction for a moment. And it may be that that's my concern about the document, or as Dee Dee mentioned, you know, what is it? I'm not worried. It's not really a report either. It's just basically this is what has been discussed. But I think once it gets down to becoming a quote discussion draft, then it gives the appearance of unanimity. And that's what I'm concerned about, because then what happens is if someone goes up there from this group and argues against it, the particular provision, then someone's going to say, well, Deborah, you were at those meetings. I mean, you didn't agree with it. We thought you agreed with this because we looked at the discussion draft. That would be my concern, because it could be used in, but I agree with you very much that let's put the shell out there, and then if someone wants to use the shell with that disclaimer language, they can do that. Because it's still going to take a representative or a senator to drop a bill on this, even if they want to use this as their shell. But I think it's important that then it's tied to that senator or representative. It does not tie all of us to every word that's in the document.
Madam Chair.
That's fine too. I mean, I'm just making a suggestion, and if you all just want to have it as a report, that can certainly be done, and then we can distribute it to all 112 of us, and leave it be to those who are drafting the bill to maybe peruse through and utilize some of the language that we have in here. So, I mean, I'm open. It's just I wanted to make sure that we're honoring the work that we've put into it the last several afternoons at different places. Yes?
At least a couple of vantage points, and I'll start with the work of this group here. I think from the outset, the way this has been presented is that there are areas of unanimity, and I'd say a significant majority of this reflects that. That I think is going to be useful to both legislators and, speaking as a former bill drafter, I think it's going to be really useful to whoever gets the daunting task of being the lead drafter on creating an ethics commission, because it's going to reduce the need to go back and create something out of whole cloth. I've always thought of this as being like a menu. I sit down and I'm thinking, well, I'm going to order this, or maybe I'll order that. There's at least 7 or 8 instances in here which are bolded to call attention to them that you could go this way or you could go that way. And these are policy choices. Obviously, representatives or senators are going to fall, they're going to have a different view on things, but I think it offers people thoughtful options for the policy debate that's going to get underway in less than a month's time.
And one other thing, Madam Chair, is you made an excellent point this morning during the discussion with Secretary of State that this is not just about politicians. It's not just about what we probably in this room concentrate on. And I think what it allows by doing like the menu, which I think that's a much better way of saying it, of what I was trying to explain, was a great idea. But we've not addressed, as you pointed out, the big picture, really, once you get out of just the political side, the politician side. And so we don't want maybe the legislators to think that, you know, this is the all-encompassing work of the committee, because some of them we just haven't been able to get to yet, from a timing standpoint, because it's gone very well, but this is a major, major undertaking.
We all support it, it's just the devil in the details.
Exactly. Exactly.
We all want it.
It's a whole host of devils, actually. It's a whole host of devils.
Oh, yes.
Madam Chair, I actually wanted to raise a couple of specific issues that I haven't heard talked about, that I had questions about, and maybe that they were dealt with in an early reading, but the first one was section 3F, which deals with the commission itself and having the governor's appointee serve as the default chair. And I'm just curious as to why we chose to have that.
That was just so you know, that was discussed earlier,
And the reason for that was, it was a way to think about the governor in this process. And as the commission's currently constituted, there's four commissioners directly appointed by the legislature, 2 appointed by those 4. So that's 6 commissioners in a legislative universe, say, to speak broadly. And so since the governor has just the sole representative, it's a way to give a little bit more balance to the commission. Granted, the chair doesn't have a lot of powers, but chairs can set agendas and whatnot, but everything has to be done by majority vote, quorum, et cetera, et cetera. It was a way to give a little bit of sweetener to the governor's office to address the imbalance of the structure of the commission. Most commissions are, it's closer, it's like a 5-3 or 4-5 or something. There's this closer balance between executive and legislative appointments. And so it was to address that structural anomaly.
Okay.
That's why.
Thank you. That helps me understand why that choice was made.
And I'm sure that question will be asked again. Meredith wasn't there, she asked the same question.
And Rob, that's also part of the menu. If you notice, there were 2 choices.
Is there a
and actually, no, we
I was choosing dim sum, but the other question was on section 7, 8, subset 8. Where we talk about the qualifications for the executive director. And I would hate for us to limit ourselves to someone who's a former judge, or a member of the New Mexico bar. Given that this is the first real ethics commission, we're gonna not hire somebody with experience most likely. So there may be someone serving in Pennsylvania who's been a member of their bar or has 10 years experience running a state ethics commission who may want to come out to New Mexico. And I would hate for us to limit ourselves to a pool of candidates that is so narrow. And I'm just wondering if that's been discussed or if there's a rationale for that. I would think that if you wanted to make it a member of the bar or someone with a legal education at JD or a member of any bar, or perhaps you could also then add in serving in a similar fashion for 5 years, so that you could allow for a broader pool of candidates.
I believe, Madam Chair, and I just had a sidebar here, that we pulled that from the President Statutes on Judicial Standards Commission. It'd be very possible to write in language saying that if you weren't a member of the bar, you would be a qualified member of the bar within a year. And I think our legislators would want to see that. Though it wasn't Representative Alcone, Madam Chair, who flagged that permission as excluding too many people anyway. I know my personal view is I like it being a member of the bar, or a district court judge would have had to have been a member of the bar. Because being the executive director is different than being a commissioner, right? And there's something to be said for being trained in legal analysis. But I could also see writing in...
Lawyers are terrible managers.
Right.
Sorry,
Not necessarily. Not necessarily.
We're not known for being the best managers.
But I think, at judicial standards, it's generally 2 attorneys, a staff person, investigator. We're talking a small group of people And so I think, and the executive director is making a lot of legal calls, right? When they go to the commission, who might or might not be made up of lawyers. So you need someone there who says, this looks bad, but it's not a violation of the Gift Act because it is kind of for sneaky reasons. Or this looks like it's okay, but it actually is a violation if you read these two acts together. You need, and I think the executive director is the right person for that. I wouldn't want to see those restrictions on a commissioner, but I can see it in the role of an ED.
A legislature does that all the time, the legislature does that all the time. And they have got attorney guidance to provide help and support for them. I'm not sure that that is that different of a policy process in this role that either a staff attorney, whether it's provided by wherever within government or in other ways, could provide that sort of guidance to the commission.
My suggestion might be then, if we were to remove it, because I see some agreement, then require the executive director to hire a general counsel. Because if we remove that, you could have a commission made up of no lawyers or no one with legal training at all, judging a pretty large body of law. So again, I don't really have a dog in the fight, but just thinking of how they work. So if the consensus were to remove that requirement from the ED, I think you would want to require the ED to hire a general counsel. You need a lawyer in the building, I would think.
If I remember correctly from several of the other pieces of legislation, there has been a retired judge appointed. There's been a member of our judiciary that has been but the bills that I remember anyway, and I don't claim to have the best memory, but I know that there was a member of our judiciary that was, indeed he has there you have it. I left everything at home. Kids' day today was just down. But it was in there, and I think that was part of what we had. And it could get amended out, it could get amended in, we don't know, but that may be a concern.
In some of these laws, actually the judiciary was part of the appointing authority for, I'm just looking for the members of the commission. I'm not finding it. But did I read this correctly, the current proposal, that the chairman of the chair of this commission must be a lawyer? No. Okay, it's just the director.
The executive director.
And so you'll have both the director as a lawyer and the chief counsel. So you're going to have two legal expertise.
Maybe it's just the executive director is a non-lawyer, and then a non-lawyer then hires. But I think if we're reflecting on the discussion, I think the discussion today has been, there's another option, have the executive director, it could be a non-lawyer or a lawyer, frankly, and qualified to be the one to hire, and then that, however, though, the executive director would be required to hire general counsel.
If I may, Representative and Senator President, if you look on page 9, that subsection F, right now hiring of a general counsel is discretionary on the part of the director. The director may hire a general counsel. So that's what I was suggesting is change that to, were we to remove the legal training from the executive director's spot, I would recommend requiring a general counsel to be hired. And again, I believe this is taken from judicial standards, statutory structure. And part of it, if you end up with a commission that was just, as I think judicial standards was for years, it was an ED and a general staff person. So you had a two-person body.
But,
This is called legal.
and I'm a lot of people know I have strong feelings about judicial
I
standards.
agree.
It is an entirely different function. They are literally just talking about law. That's what they're doing day after day after day. This is not just talking about law. I do agree with you that lawyers are required, but I don't agree that the executive director should be a lawyer, and has to be a lawyer, could be a lawyer. but it doesn't have to.
Maybe.
I just
And
See what
could-
happens during session.
Licensed by the New
But I'm just saying,
Mexico
I'm just
law.
expressing my opinion,
Right.
that I'm frankly, at the legislature, I mean, I'm gonna be using judicial standards a lot, but as a contrast, because I really worry about how judicial standards has been operating all these years. And I think the pushback actually comes from the judges, because I think you give them that kind of power and authority, bad things can happen and have happened. And so I'm really concerned about it.
And even on that context, just questions that still continue to come up, is that for this director, also too, it seems like he or she can sit there for quite a long time, and how we have talked about removal for cause, but should they not be subject to an annual review, falls under, if they're a state employee, they fall under the State Personnel Act. I mean, there's a lot of other things that come into venue. And if they do an annual review, they still have to come in front of the LFC for a budget request, and there are still some parameters that the LFC puts on them in regards to how many hearings are we having, all this other type of stuff that they do in order to continue receiving their $1 million or whatever we get into the budget. So I mean, there's still some additional things that we will have to put in here, because they should be subject to an annual review, so that they're not sitting there as the king or queen that has the direction on many other people's lives that come in front of them from a complaint, whether it's signed or not. I mean, there's all these other scenarios that could, but how do we also make sure that the commission will have oversight and can deal with the executive director, but we also have to make sure that the executive director is not set up as a king or queen, and that they still have somebody to answer to. And it may be just because of the financial question, because the Judicial Standards Commission kind of operates out there, but they still are a line item. And we got to figure out also how to take that into context too, with the unified budget and all the other stuff that, I mean, there's so much more that we could do to maybe improve on that one. But that's just something I want to throw out as we talk more about this bill as it gains its life. However, the bills will turn out, but that's also in addition to your question on what their education may be, but also to how we make sure that they come under review, annual review, and it's not just removed for malfeasance and such, but what else can be done? I mean, that's still some guidance on state personnel, because they'll be a state employee. So, just things that we also have to look at as we massage this on that one. So,
We have a question over here.
yes, sorry.
And I was just asking Deborah, we were talking about this, and going back to wanting to, at the beginning, cover as many people as possible, so you don't have to bring people in later. If you are employed by UNM or NMSU, are you considered a state employee?
A board member?
No, just someone working for the university.
For purposes of retirement, you are.
So this would cover all university employees as well?
Public universities.
Public,
Universities,
okay.
Because they're funded by our state tax dollars.
Okay,
Yes.
all right, good. Thank you.
This brings me back to a question, because I'm
The Government Conduct Act.
feeling very uncomfortable that we're not really clear on page 3 on who this covers in terms of those other folks. Like the state official means a person elected to an office or executive or legislative branch, this is M, of the state, or a person appointed to a state agency. And, it seems like we should say council, board, commission, and make it really clear. And then I know that Senator Lopez and I have been also wanting to make it really clear that it has, that the ethics provisions need to cover more than just the school election campaign reporting act. Somehow or other, where we are looking, very narrowly here, so either adding an O in this list, someone, like in other words, what if there's something unethical that happens with, I'm just making up a scenario right now, let's say, volunteer at a school where there's an ethical violation, is that person covered by this? That person's not an employee. That person is not an appointed, appointed to a board commission. I think that we need that language. What happens there where there's an ethical breach and that person is in a powerful position trusted with resources or whatever, and it doesn't have an official capacity?
Madam Chair, I think what Meredith's referring to probably goes directly to the current definition of state agency, which is subsection K on page 3. And we had a pretty long conversation about that in one of the earlier meetings. You can play with the definition of state agency any way you want to. It's pretty broad right now, but if you want to put in a laundry list, which we did in the first draft, then the problem is that we unwittingly leave something out of the really extensive laundry list.
So is a charter school a state agency?
Yeah. It's a public
Is a
school.
county commission a state agency?
No.
So I think, since this does cover local governments, shouldn't we have something about a state or local government official? Something, because this does cover county
Yeah,
commissions.
I want a clarification on that. Is a county or city not considered a sub-jurisdiction of the state?
There you go.
But it falls within the
Yeah.
confines of the state constitution and all those other laws, right? So that's how I read state agency, as it encompassed the sub-jurisdictions of the county and city. But if that's not correct, we really are limited with these definitions.
Yeah, Emma's troubling.
Well, and another issue that came up during some discussion with the legislators is, what do you do with the home rule city?
What do you do with what?
The
Home rule.
City,
Arnold City?
Albuquerque, Las Cruces, I don't know, Santa Fe, Santa Fe, I don't know. But there's home rule that's there. That's gonna be something that I think would have to be, let's say the council service would have to give us some guidance on that.
Actually, I can, what they would have to do, Madam Chair, Representative, dealt with this issue a number of times. What our courts have said is they would have to write an overrule of home rule in the statute. So it's not presumed, but the legislature can do it explicitly. So, and to your point, Meredith, as well, I sent some notes to Tony about things, as we included those more local acts, like the Local Election Act. And I just said that when this goes to LCS, one of the things we have to flag, we would probably do it anyway, because this stuff, of course, is looking at some of our definitions to make sure we include some of those local officials. When this was originally drafted, remember, it was a much narrower universe of acts. And so those definitions corresponded to those acts. As we've added acts, that means we'll have to go back and re-engineer the definitions to make sure the definitions correspond to all the acts that have been added. So you've got a good thing. And that's going to be sitting down, what'll have to be at is sitting down with those full acts. So local action, actually with the local action, or what's it called, Local Elections Act, only because it was passed recently. I'm not even sure if there's enforcement provisions, and I couldn't pull up, the Compilation Commission website was acting up. I couldn't actually pull it up on my thing.
I wondered
So
why
there's
that
some-
was in there.
There's some, that was almost a placeholder to make sure there isn't anything, but I just couldn't pull it up. So we didn't forget it because that's such a new provision. But you're right, we will have to rework definitions to make sure that's why really that enforcement section 8, we probably should have started there because everything expands out from there. The definitions we'll have to, or the drafters will have to make sure that they include those definitions. But they're good at that, particularly if they get someone who's really experienced at LCS, and they'll know that they need to pull all those things in.
So can you make it, a note, I think Rob was suggesting some wording about, or any state subdivision, like a local government, county, municipality or whatever, just even to add that wording in so it doesn't get forgotten in that M on page 3.
And we could probably put something, but again, like I said, you mean state official?
Yeah.
Or both state official and state employee would need it. And candidate as well. Those are all 3 places that we flagged. The definition of candidate, because Campaign Reporting Act doesn't cover all these candidates as well.
So,
But as we've added these additional acts, then we'll need to expand the definitions.
yeah, just any wording to get the local subdivision, something like that. And what about like the soil conservation district employees and, those are commissions, commissioners and so on. That's the reason I thought it would be better to be explicit about, the councils, boards, commissions and so on. It's better to have something spelled out so that everybody says, oh, okay, this is clear, than to have somebody say, well, I think a state official is only somebody who works for the state. It can't be a county commissioner, it can't be a soil commissioner or whatever.
Well, I think that the concern is if we use like soil conservation versus an agency, state agency. State agency covers a lot of things, commissions cover a lot of things. I don't think we would want to name all of the commissions.
No, I'm just saying.
Okay. The other thing we need to keep in mind is when you go back to the constitutional amendment, it does talk about initially that it's going to be state officers and employees of the executive and legislative branches of government, candidates or other participants in elections, lobbyists or government contractors or seekers of government contractors. And then we put in language to cover what we're really discussing right now and have such other jurisdiction that's provided by law, which is the Enabling Act. I mention this to you so that if it does come up, well, my gosh, you've now expanded this so broadly from the constitutional amendment. We really haven't, because we did have that phrase in there purposefully, because we didn't know how it was going to shake out on the enabling legislation itself. And that's the ability then, at this time, with what the legislature passes, to be covered under the Constitution.
So just adding in as provided by law?
Well, no, as far as the constitutional amendment, that's what gives us,
Yeah.
it gives the legislature authority to be more specific.
And if you look just for cross-reference on page really 12, going on to 13, starting at the bottom of 12, people against whom a complaint can be filed or investigated as candidates, state officials, acting capacity, state employees, government contractor, lobbyists, elected or appointed local government officials acting in official capacity, elected, actually it should be elected or appointed public school official, typo, in 7, and then 8, a person appointed to any board or commission in the state. So that kind of is a shopping list of people against whom complaints can be filed or the commission can open an investigation. But we probably will have to go back and tweak those definitions a little bit.